Ladies and gentlemen, good day or good evening, wherever you are. Thank you very much for joining us for this webinar. My name is Bharat Anand, and I'm a partner in Khaitan's corporate and M&A practice group. And I would like to extend a very warm welcome to each and every one of you, whether you are dialing in from India or any other part of the world. The agenda for this afternoon, or rather the order of events, is really set out on this slide. So we will have a panel discussion for about 60 minutes, followed by a Q&A session for around 15 minutes. We've received a number of registrants, and several of them have actually sent in questions in advance. But if you have any questions, please do submit them through the facilities that have been provided. If we can't cover all the questions, we will certainly get back to you over email with a response. And also please bear in mind that a copy of the presentation, as well as a recording of the webinar, will be sent in due course after the proceedings. So really the topic of this webinar is what Indian companies need to know about international arbitration. In 2019, there were as many as 870 new cases registered with the ICC system. And the cases arising from Southeast Asia were as high as 20%. India figures very prominently amongst the nationalities that are being represented within the ICC system. You can see approximately in 147 cases, you had Indian domiciled parties participating, second only to the United States. But it's not only in the ICC system that Indian parties play a prominent role. In fact, this slide, which is from the 2019 annual report of the Singapore International Arbitration Center, shows that Indian parties are actually the most dominant nationality of origin at SIAC. And as a matter of interest, international arbitration disputes being handled through SIAC have actually doubled in the last 5 years. So this brings me to our expert panel. Every person who is registered for this webinar today has already received an email with the full particulars and credentials of our entire expert panel. So I will not spend too much of time in repeating or summarizing their experience. Suffice it to say that they are all arbitration experts with excellent arbitration credentials. However, we are very fortunate to have with us today 3 international arbitration experts on our panel who are each experienced, particularly in dealing with Indian disputes. John B. is amongst the best known arbitrators in the world, having served as chairman, party appointed arbitrator, sole arbitrator on international arbitration tribunals in both ad hoc and institutional arbitrations. David Joseph QC is a barrister, advocate, arbitrator, member of the bar in England and Wales, and is well recognized not only in the English courts, but across the common law world as an authority on international arbitration. Darius Kambata has been designated as senior counsel in India since 2005 and practices before all senior courts in India. They are joined by 2 leading Indian general counsel from the corporate sector, Hemant Kumar, general counsel and head legal at Larsen & Toubro, and Deepak Chauhan, director and head legal at the Welspun Group. The panel is made complete by my fellow partners, Kinshuk Banerjee and Raj Panchmatia from our disputes practice, who are both very experienced in international arbitration. I would like to kick off now and would just request the panelists that as they respond to some of the questions that I will put to them, if they could contextualize it in terms of sharing some war stories and some experiences. So really, Darius, I'd like to kick off with you. Why should an Indian company prefer international arbitration to the courts of India or to the courts of any other country?
Thanks, but really the question answers itself. It all depends on what sort of dispute you have. Increasingly, with India's growing economy and with its engagement in the world, both in terms of trade and investment, you are having trans-global transactions. Indian companies are now going out, investing in foreign jurisdictions, trading with foreign jurisdictions. And the moment you have trans-global transactions, you'll have trans-global disputes. It's obvious that the most commonly accepted means of resolving trans-global disputes is something which offers neutrality to the parties. So whereas you might want to file in your own jurisdiction, which is India, often you don't have that ability because of the lack of residence of your counterparty and perhaps because of lack of assets in India. You could file a suit if there is otherwise part of the cause of action in India, but you then run into problems of enforcement of an Indian judgment in foreign jurisdictions. And you don't always have reciprocity. I mean, it may surprise us to know that even today, there is no reciprocity of enforcement of judgments between the US and India. And I hope that that gets resolved soon, but that's the fact today. On the other hand, international commercial arbitration resulting in an award that is enforceable under the New York Convention is a time-tested method of enforceability. It was once said that the New York Convention was the most successful international convention ever. And I rather tend to believe that. India, of course, was a very active participant in its drafting in 1958. And if you read the Trevor, you'll find a lot of interventions from the Indian representatives on various aspects. But today you have a structure which is now firmly in place internationally, which gives 3 or 4 huge advantages when you're talking about trans-global disputes. I think the first advantage is neutrality, because in trans-global disputes, you have lawyers from different jurisdictions, parties from different jurisdictions, assets in different jurisdictions, and neutrality, and particularly neutrality under the aegis of a good arbitral institution, is a tremendous advantage in dispute resolution, in getting awards, and in getting enforceable orders. That's the first. The second is, of course, the fact that over time, there is a vast body of international practice and convention that has built up around international commercial arbitration. There are strict timelines, there are rules, there is strictly no ambushing of your opponents, matters are disposed of within a fixed time frame, there is monitoring from an arbitral institution. So you have the security of a time-bound dispute resolution mechanism. Now, all of us may not like that, depending on which side you're on, but I think by and large one can say that in a commercial dispute, both sides want a speedy resolution. Thirdly, there is now a huge body of accredited and very experienced international arbitrators. And some of them, of course, are Indian, but there are also arbitrators of other nationalities who have the attribute of neutrality if it's a dispute between an Indian company and any foreign organization. So you have that third advantage. But I think the greatest advantage of international commercial arbitration and a foreign seated arbitration would be enforceability. As I said, the New York Convention is now accepted as one of the most successful international conventions today. An international New York Convention award really has an independence of its own. It's no longer rooted in the law or the jurisprudential matrix of its seat. It's really an instrument of international law. And in 2 important cases recently, this was brought to the fore. Take the famous case of Dalla, where the Supreme Court of the UK refused enforcement to an award made in France. And a month later, the court of the seat, that's the court in France, actually upheld the award and rejected the challenge to it. So the seat upheld, and enforcing jurisdiction refused to enforce. The exact opposite was the Putrabali case, where the seat, the law of the seat and the court of the seat set aside the award, and yet it was enforced in France. And that's a very important principle, because that showed that notwithstanding the fact that the seat of the arbitration upheld the challenge to the award, an enforcing court recognized it as an independent instrument of international law and was willing to enforce such an award. So I think enforceability today is critical. And of all the conventions you have, enforceability of an award is today the easiest in a spectrum of choices that one has. Lastly, I should say that at least in India, enforcing foreign judgments requires you, if it's not a decree for money, where you can directly get enforcement, with any other type of decree, requires you to file a suit. And a suit is then subject to the rigors of Section 13 of the CPC, which gives a far more intrusive judicial review than does the New York Convention or the Indian Arbitration Act. And therefore, it makes more sense to have a foreign award which you want to enforce, even if you're enforcing it in India, than a foreign judgment. I think very briefly, these are the 4 or 5 reasons why it makes sense to go for foreign arbitration, as opposed to.
Yeah, thank you, Joyce. That's very, very helpful, and particularly the way you explained not only the enforceability but also the transparency and the entire edifice that is now supporting international arbitration and what is fueling it in terms of national transactions. So, John, if I could maybe turn to you in terms of the consequences when it comes to choice of applicable law in international arbitration, and really what are the different systems of law that could potentially apply?
Thank you very much. I have about 4 minutes to cover a subject which is normally the material of a series of lectures, never mind one. So this is going to be necessarily very high level. And to those of you who are familiar with the world of international arbitration, forgive me if I seem to be being somewhat superficial and skating over the surface. But it's worth stepping back a little bit in light of what you've heard already from Darius, and make the point that arbitration is still seen, despite all the efforts of some to knock it off a pedestal, it is still seen as the most effective and globally adaptable means of resolving all manner of commercial disputes. And Sundaresh Menon, the Chief Justice of Singapore, has described it as having a critical role in the global administration of commercial justice. The critical point to bear in mind is that this is not litigation by another name, and not just litigation in the sense that it's all happening in one particular domestic court. This is a consensual process. The parties must agree to arbitrate. They must agree how to arbitrate. Are they going to arbitrate under the rules of an institution? Are they going to operate ad hoc? They need, as Darius has already commented, to work out where they're going to arbitrate. And issues of neutrality, a sympathetic court, a supportive court system, an ability easily to enforce any award. These are all matters which will have to be considered. Then comes matters such as what language is to be used in the course of the arbitration. Now, many of you will be familiar with taking a case in front of an Indian court, applying a contract governed by Indian law, where you'll be looking for enforcement in India pursuant to Indian law. Contrast that with the sort of international contract to which Darius has already referred. You have a US counterpart. You don't want to go and litigate in the United States because of punitive damages, because of excessive discovery, because of jury trials and all the rest of it. And that, incidentally, is one of the reasons why it's not just India that has no reciprocal enforcement treaty with the United States, but nor does the United Kingdom. And as far as I can see, it's going to remain that way for quite a while yet. But there you are, you've got a US counterparty. You decide that you won't go for the law of New York or the law of India. You'll apply English law to the contract, and you decide to arbitrate in Singapore. You then end up with the parties being involved in the selection of an arbitral tribunal. That tribunal is going to need to determine the merits of the dispute according to English law. The arbitration will be held in Singapore, where it's subject to the supervisory jurisdiction of the Singapore courts, which means that it's the Singapore courts that to which application is made if interlocutory relief is required, or if indeed ultimately there is to be a challenge to the award that has been made. And then you've got to consider about enforcement. It could be India, it could be the United States, it could be any other number of countries. And there again, we come back to Darius's point about the importance of the New York Convention and the fact that over 160 countries have signed up to it, and in theory at least, and in some cases it's more difficult than it would appear, there is readily an ability to enforce an award that is made and is not being set aside in the court of the seat. Now, in many cases, awards never have to get to the stage of enforcement. Parties accept the result. They may not like it, but they accept the result that the tribunal has reached. In certain cases, there will be an application to enforce the award. And generally, and I'll give you an example in a few minutes' time, generally the court of enforcement produces a decision which a court will have, forgive me, the court which is not upheld a challenge will find its decision followed by an ultimate court of enforcement. There are some exceptions, notably in France. Coutravani has already been mentioned. Hill-Martin is another. But perhaps more in line with the way in which things operate is an example which comes from Nigeria and from England. And this is a case called AIC Limited and the Federal Airports Authority of Nigeria, where the English court was faced with an application to enforce an award made in Nigeria, while proceedings in Nigeria to have it set aside were pending. And the case arose out of a dispute between AIC, which is a Nigerian construction and property development company, and the Federal Airports Authority of Nigeria. And the dispute turned upon a lease of land at the Murtala Mohammed Airport in Lagos for the construction of a flight path hotel and resort complex. The award rendered in Nigeria, which was the place of arbitration, was subject to a set-aside application by the losing party, the federal administration. While that application was still pending, AIC sought to enforce the award in England, and the English High Court, in the exercise of its discretion, which gives effect to Article 6 of the New York Convention, decided to adjourn the decision to enforce the Nigerian award until the set-aside application had been concluded. The English court applied the criteria set out in English law. It considered whether the application before the court in the country of origin was bona fide and not a delay tactic, whether the application before the court in the country of origin had at least a realistic prospect of success, and finally the extent of the delay occasioned by an adjournment and any resulting prejudice. And it concluded that in the circumstances of the case, it was more appropriate to hold its decision until the set-aside proceedings had been concluded in Nigeria. Now that's perhaps an example of an exercise of judicial comity and an effect to strike a balance between upholding the principles underpinning the New York Convention and the avoidance of conflicting judgments. And it's indicative of the fact that one can draw certain conclusions about jurisdictions in which one chooses to arbitrate. If I might take a historic anecdote, which has changed in the course of time, and that the UAE and Dubai are now New York Convention signatories. Some years ago, I represented a company, I think a representative of which is listening to this webinar, which was involved in a dispute over what was then the new Dubai airport. We assembled in the Dubai Arbitration Center to be heard in front of an eminent European arbitrator appointed by the center. This case was somewhat complicated in that it involved the cross-examination of a leading member of the royal family of Dubai. My firm had shut its office in Dubai on the off chance I might get the cross-examination wrong, and it was ready to leave at a moment's notice. However, we proceeded with the cross-examination, but only on the basis that this member of the royal family had been given a special indulgence as to the nature of the oath that he would take. This was a combination of words put together by the then Attorney General of Dubai. It was approved by counsel on that side. It was approved by us. It was approved by the sole arbitrator. My clients won, We then had to get the award ratified through the courts in Dubai before we could apply for enforcement. And at each and every stage, all the way up, we were turned down on the basis that the wrong oath had been administered to the witness. The French courts finally got to hear about this and took a rather different view, and the award was upheld in France on the basis that there'd been an egregious breach of what in France would be regarded as public policy considerations. It's there, it's called DUPCO and BKNI, but it's there for reading as an example of what can go wrong.
Right.
Not too often, it normally goes right. Thank you.
Yeah, terrific. So thank you, John. And the point that you make, that one has to really think through, right from the inception, who you're dealing with and where your arbitration is being planned, and what the ramifications of enforcement subsequently will be, is really important. And in that context, David, I really bring you into the discussion in terms of seat of arbitration and what are the issues, particularly if you're advising an Indian company, that an Indian company should consider in terms of the seat of the arbitration.
Thank you very, very much. Well, you've already heard a bit about the question of which process, court or arbitration. You've heard a bit about what issues of law may impact, governing laws may impact on your process. So I'm going to discuss the where, not the what and the why, but the where. In the age of Zoom, you probably would say that the question of your seat of arbitration has never been a more important and relevant question. Why do I say that? It's because there is actually a fundamental distinction in arbitration between the legal anchor, the seat, the place that you choose to anchor the supervision of your arbitration process and any challenge to the award. That is the legal seat, and the geographical venue of where you argue. Now, I know this sounds like a long time ago. Back in the day, in 2019, we all got on aeroplanes and went around the world. It was all extremely expensive and so on and so forth. And now we have Zoom, so you can actually do your arbitration remotely, a bit like today. We're all sitting here in our various different places and locations discussing these topics, but you don't need to travel. But what you do need to do in arbitration is choose a legal seat and anchor. Now, what I'll touch on two things. It does actually have a big consequence in terms of the amount of court interference. That's the first thing. The second is the grounds of challenge to the award. But before we get there, I want to say, do make a sensible choice. Okay, so Darius and I, we did battle against each other for very, very nearly 10 years in a case where the parties saw fit not really properly to make a choice at all. They thought what they would do, I don't know if this expression works, but it was like a licorice all sorts. They decided to put into their clause a bit of India, a bit of England, a bit of everything. It did not work. It entertained the Indian Supreme Court in the case of Enacon for a long, long time. It put a little bit of money into Darius and I's bank accounts, but it served no other purpose. So rule number one is make a sensible, clear choice. Rule number two, I would say, is choose a venue, a seat, sorry, that has a strong reputation for international arbitration and the upholding of the arbitral process. Why do I say that? Because what parties really, really want is to get to the end of their dispute. I think most people on this webinar would agree with that. The trouble with a never-ending process is ultimately it probably only serves the lawyers. It doesn't ultimately serve the client's interests. Now, I'm not going to go on a sort of a bandwagon of where you should go. There are a number of different neutral venues, of which we saw a slide earlier about Singapore and how popular that is with Indian parties. Dubai is another example. I've got to make a bit of a shout for London, which is also extremely popular with Indian parties. But there are many, many others in Hong Kong and so on and so forth. So choose a good neutral seat that has a strong reputation. So just very quickly, in 1 minute or so, court supervision. In England, that is absolutely minimal. It really is minimal. It is a rare case that ever goes before the courts during the arbitral process itself. There was one quite recently, which of course is the Halliburton case, which went to the Supreme Court and interrupted the arbitration for about 4 years as to whether or not one of the arbitrators was truly independent and impartial or not. But it is the rare case, it really is. And then you have the ease of enforcement. And all I would say is, if you're choosing a neutral seat, which has a strong reputation in upholding international arbitration, you're going to get enforcement figures in the high 90%. Just think of that for a moment. That is a massive percentage. You will be choosing a place that in all but 1 in 20 or so upholds the award, because the drive is towards upholding the party's award, which is the product of their bargain. Now, those are the figures in England. I think those are also the figures in Singapore. There are, of course, the exceptional cases, and the Astro case in Singapore was one prominent one. We've already heard about Dalla in the English courts, but these are the exceptions that prove the rule.
Right.
So I would say to parties, choose a neutral seat, and one which actually upholds the principles of minimal interference and enforcement of awards. And
yeah, thank you, David, for making that principle very clear. And the seat being the legal anchor, and really getting some advice at the right time on that, and thinking through that, unless you want to enrich your lawyers. I'm sure that's a takeaway that will stay in many minds. But I think, Kinshuk, if I could quickly ask you, because we've got a number of attendees attending from India, and the question therefore obviously comes up that, look, if the parties want to go, if 2 Indian parties want to look for a gold standard seat outside India, is that doable? What are the implications?
So look,
yeah, I think that's.
Oh, sorry.
Yeah, David, go ahead.
I apologize.
No, go ahead, David.
Was that was for me? Was it?
It was for Kinshuk, David. But if you want to quickly give your views, that would be great.
All I'm going to say, and I'm not going to tread on Kinshuk's toes, but all I'm going to say is that there are different considerations for a number of these different seats, but there are differences in the underlying Arbitration Act, and you would be advised to take advice on that. So if, for example, you're comfortable with the English Arbitration Act regime, having that level of comfort is important. And likewise, if you are equally happy with the Singapore Act, again, that's important. But there are differences, and even John's example in the Dutco case, it highlights some of the differences in the local arbitration acts. I won't say more than that.
Kinshuk, 1 minute. Can 2 Indian parties choose a foreign seat?
Yes, I think briefly put, Bharat, that's now possible. At least 2 high courts in India, Gujarat High Court and Delhi High Court, have said that 2 Indian parties can choose a foreign seat of arbitration. And so therefore, that's an interesting mix to this. Though it's strictly a domestic arbitration we're talking about, it's possible, Bharat, to answer your question. There are implications, but I don't want to get into that because I'm conscious of time.
Terrific. So let me just let's talk a little bit about arbitration institutions and rules, and what is the right choice, Raj, for an Indian company, and how do the rules and the institutions really compare if you were to give the audience your comparative assessment?
Yeah, sure, thank you. But before I go on to that, I just had one comment, and if it's okay, on the one what David mentioned, and is that I have had an experience that we had a seat in a place which itself had a very peculiar laws on arbitration. So when you pick a seat, it's also important to know what the local laws of that seat are. Otherwise, you can get into so much trouble in your arbitration that it's like an operation successful, patient dead, and you will go through the whole process, but you will not be able to get an award which is enforceable at the end. And if you've not followed the peculiar procedures that are required to be followed in that jurisdiction. So that's something that I've had an experience with, and we've had to deal with it. So I thought it's important to mention that. Well, as regards institutions, I think all institutions today, all international institutions today, like be it ICC, LCIA, SIAC, HKIAC, all have very robust set of rules. And I think all the rules are being looked at by experts such as John, David, Darius, who are on the panel looking at the rules on a regular basis and trying to update them on a regular basis to bring in the necessary improvement that are required. In the last 2-3 months, we've already seen ICC, LCIA updating their rules. SIAC is on the verge of updating its rules. So these rules are all getting updated very frequently. So it's very, very difficult sometimes to choose one rule against the other. But I think I would go with all the situations which Darius, David, and John mentioned in the past about where you are seating the arbitration. What is the nature of your arbitration? What is the nature of disputes that you're going to see in a contract? Because these things will have to come in and look at right at the inception when you're drafting a contract. Because you are going to put in which rules you want to go with or run with. You will look at it right at the inception. So some basic understanding of the rules that you are going to choose is very, very important, because some of them may have an early dismissal process, some of them may have consolidation process. It's very important to see what you are likely to face in a dispute. It's not just that you are bringing in an institution or a rule because somebody has told you that it's a good institution and a good rule. It's very, very important what will be suited for your matter if it goes into dispute. You need to be very, very careful, and somebody who's drafting it and putting it in, it's important to at least have one quick read through of the rules, what it's likely to be that you're going to face. You don't want a situation that some of the institutions also provide for a default seat. Now that's not something that you would have contemplated at the time of going into an arbitration. You might have skipped that provision. You may not have contemplated that there is London as a default seat. You may have thought that, okay, I'm taking the rules of a particular institution, but I'll have a seat of arbitration somewhere else, and you probably inadvertently missed out to put a particular seat in a particular jurisdiction, and you landed up in a seat which is either London or some other country. Now that may not have been your intention. So you have to be careful while choosing a right institution. The rules of each institution are extremely good. They have consolidated provisions. They have early dismissal provisions like LCIA, SIAC, HKIAC. All of them have early dismissal provisions. So it's very, very important that you are looking at them. So these are some of the important things that you need to keep in mind.
Right. No, thanks, Raj. And it's almost as if the institutions are in some ways in some sort of competitive federalism in terms of friendliness towards arbitration. And I also noticed that you stayed away from costs. So that was very diplomatic of you. But I think let's bring in our corporate panelists here. So. Hemant, I'll turn to you as General Counsel of a large Indian corporate. You have had a great deal of experience in international arbitration. So can you walk us through your experience? And generally, has this been positive? Has it been negative? Or otherwise?
So thank you very much, Bharat. I've heard four, my panelists. All are either from law firm or advocates, senior advocates. As a general counsel, we decide in a different way. Let me tell you very frankly. Before we state would go in arbitration or suggest arbitration, whether international or domestic, we first examine whether we have the merit in the matter or not. Because for us, our main focus is to do our business in the best way, not to do the business of litigation. So cost is the most important factor for us. Second thing is that if I find that my case doesn't have a merit, then we always try to negotiate with the party and go for the negotiation and friendly settlement. If that also fails, then as a general counsel, I suggest mediation and conciliation. If both these steps doesn't work, then only as a general counsel, I advise for arbitration, number one. As regards my experience on international or domestic arbitration proceeding, I admit that prior to October 2015, as a general counsel, I was little inclined to agree for international forum, as they indeed decide the dispute in time-bound manner, but it's costly. Cost affairs is the most important factor for us as a general counsel. Post 2015, you know that a lot of changes has taken place, and therefore I now suggest to follow domestic arbitration. Of course, domestic or international arbitration both depend on if both the party agree that whether the other side also will follow domestic or international arbitration. But as a general counsel of Larsen Toubro, I prefer domestic arbitration. There are few disputes, even post 2015, where the tribunal have pronounced the award in 15 and 18 months time, and we have already recovered them all. About my experience on the quality of the international tribunal and Indian tribunal and legal cost, it depends on the many factors. Number one is a selection of law firm. Now, if I select an international forum, then I'm spending cost on two fronts. One is a local law firm of Indian law firm, and again, local law firm sometimes engage the international or the particular country law firm. So I don't like these two costs for one arbitration. Number two is selection of arguing counsel. Now this is also very important, whether you are working or acting the international arbitration or domestic. Selection of arguing counsel, whether the counsel is always available for argument or he is only requesting for the adjournment. Third important is, of course, selection of nominee arbitrator who can deliver result all these three issues on a fast track basis at a reasonable cost. This is most important for general counsel. Quality wise, also domestic tribunal are at par with international forum, and I feel that in our domestic forum, domestic arbitration are most cost effective. In my career, I have also faced, when I prefer international forum, there's a language barrier, which is not there in our domestic arbitration. If a foreign, there are a couple of other points I would like to highlight here, which is very relevant for us. If a foreign seat is chosen by Indian party, the timelines prescribed under 2019 Amendment to Arbitration and Conciliation Act will not apply. These timelines, the benefit are not available to us. Second thing, if the tribunal is seated outside India, interim orders issued by that tribunal will not be enforceable in India, because only final arbitration awards are enforceable under the Indian law. By contrast, if the interim order has been issued by Indian seated tribunal, it would be enforceable in India in the same manner as an order of the Indian court. In India, the major challenge is that, this is very important, that an award delivered by a tribunal consisting of 3 former Chief Justice of India, this can be challenged before commercial courts, which is equivalent to the district court. So, this is a very funny situation that 3 Chief Justice of India pronounce an award and it is subjected to district court, commercial court. The other challenge is that I think most of these, the earlier issues that have been addressed by different courts, especially Delhi High Court, Bombay High Court, and Supreme Court, that challenge of award under Section 34 is very limited, but still I find that there are courts who interfere in such matter, and it takes time, couple of years to actually get the fruits of the final award. So this needs to be addressed properly. And to sum up, according to me as a general counsel, prior to 2015, I had to prefer international forum, but currently I always prefer domestic forum. This is my experience, which I have shared with you.
No, very thank you very much, Hemant. I think very interesting vote of confidence in favor of domestic arbitration, and I suppose your input needs to be assessed in the context of the overall comments that Reyes was making in terms of enforceability, where are the assets located, and so on. But let me also Deepak, bring you in at this stage, continuing with the corporate perspective, the client perspective. So really, how does an Indian company pick the right team? It's one of the themes that Hemant picked on, and what is really the role of the Indian lawyer in that context?
Right. Thank you, Bharat, for having me. See, getting the right team in place by far is one of the most important decisions that Indian in-house counsels would take in any international arbitration. And typically, we've seen that, this decision leads to, everything what happens subsequently in a dispute or an arbitration situation. It's a very important decision for all of us who enter into this arena. So first step that we've seen is that what's most important is to have the Indian law firm in place. So while whatever may be your considerations, it's always important to get your Indian law firm in place. Indian law firms, our experience has been that they have great experience now in dealing in international arbitrations. They have excellent skills and excellent connects. You could leverage on them. You could appoint the right team. They are well aware of the procedures and the timelines. You can leverage upon their strengths to even appointing international law firms, because ultimately you will need one overseas law firm in place in any case. Now, what we've observed is that if it's a simple buy-sell sort of a dispute, you could even opt for a boutique law firm, overseas boutique law firm, which would specialize in arbitrations. But if it's let's say a shareholders dispute, then that leads to many laws and various considerations. You would look for a large, full-size practicing law firm to be on your side, to be partnering with you in any such dispute. So those are the sort of considerations one would have when somebody is making a team and getting the right team for starting any arbitration, international arbitration. So therefore, you end up with a team which is one Indian law firm, one international law firm, and most importantly, of course, the Indian in-house team has to be dedicated with some dedicated resources, because there will be a lot of fact finding and a lot of support which will be required in terms of facts. So that support has to come from in-house. So those are the considerations which you would have. And I can share one example very quickly with you. We were recently into a dispute which was a sub 10 million dispute, and which was governed by Swiss laws, which had the seat was Hamburg, and the rules were, of course, German Institute Arbitration. So quite complex in terms of what we'd agreed. And ultimately, we had a large Indian law firm which was working for us, along with a boutique Swiss law firm. And with the help of both of them, we could now we are in discussions to get a funding agency also for this. So those are the sort of scenarios one needs to build, considering the value involved and considering those considerations. Thank you.
Thank you, Deepak. I think the cohesiveness of the unit that is put together to take on this challenge is a very, very interesting input, and to leverage from each other's strengths, for corporates who have relationships with existing firms and to then build on from there, given the nature of the dispute is, thank you for that input. So, David, in terms of the right size of the tribunal, and particularly, in the context of the composition of the tribunal, and what would be some of your advice in terms of people like us who are drafting documents as M&A lawyers? What should we think about? But why don't you comment about what you think is the right size of the tribunal and the composition of the tribunal?
Thank you very much, Bharat. Look, I'm just going to come back to what Mr. Kumar said a moment ago, because he has raised, if I may say so, possibly the single most important point so far today, which is costs. We all are passionate about our subject. We get very involved in it. We are very committed to the process, but it has a cost. And whether you choose either domestic or international arbitration has some impact on costs. And also things like whether you choose a tribunal of 1 or 3 has an impact on costs. But I'm going to address that by reference to what I think is, in essence, the core of the point, which is it's horses for courses. There will be a number of disputes which only arise between Indian parties, both claimant and respondent, and they are much more comfortable with either the Indian courts or a sole Indian arbitrator, and so on and so forth. And then there will be a raft of disputes involving foreign investors and so on and so forth, possibly of pretty substantial size, and we're all familiar with those kinds of deals. in which case, almost inevitably, you're going to end up with a panel of 3 arbitrators, and the foreign investor is not going to be content with a process which is entirely domestic Indian. And that would be exactly the same if it was an Indian investor in a foreign country, whether it is China or whatever the country is. It is a almost universal principle. They're looking for some degree of neutrality. And so the point I'm going to then emphasize is this: how do you go about not just the choice between 1 or 3? I mean, a number of arbitration rules have default provisions. If you don't make a choice, it's either 1 or 3, and so on and so forth. But that's we're addressing here Bharat's question, which is how do you go about making your choice? And the fundamental principle that I want to emphasize here, and it really is completely essential to the process: choose an arbitrator, if it's a panel of 3, as your party appointee, who is likely to be an influential voice in the panel of 3. You don't want to appoint someone, for example, that that you think is going to just be quote unquote on your side. I don't even know quite what that means in the context of arbitration, because every arbitrator is supposed to be and has to be independent and impartial. But you don't want to choose someone who you just think is bound to be on your side, because in a panel of 3, having just one person on your side is not enough. You need to have an influential voice who is then going to be able to persuade the chair, whoever that chair is, to come along with you. And it could also be, and this is a very important point in parallel, because Mr. Kumar has touched on this. You know, we've been talking about liability, but there's liability and quantum as well, of course, involved in arbitration. And it may well be that if you're in the position of a respondent, you're facing a very large claim, and your best points are to reduce the level of damages to a very moderate size, and in which case you have an influential voice who can moderate some of the excesses of the claimant's claims and to bring the claim into the kind of arena that you are comfortable with. So that's probably what I would say in relation to choice, but there would be different considerations for different sizes of dispute.
No, fascinating, really, and thank you for also picking up on the costs point, as well as some of the practical guidance in terms of what people need to think when really the stakes are high, and one is strategically opting for the international arbitration scenario as opposed to a more of a domestic kind of arbitration. So maybe Raj, just in terms of the panel size itself, if I could maybe just quickly ask you, so if we've agreed to a 3-member tribunal, is it possible to have an arbitration with a sole arbitrator?
Thanks, Bharat. So if you've already agreed for a 3-member tribunal in your agreement, but if parties want to say go with a sole arbitrator, by consent, of course, they can modify that arrangement and have a sole arbitrator, but there has to be consent of both parties to that effect. That is very, very important. And I think, again, whether you want a sole arbitrator or a 3-member tribunal, you many a times bring that in your agreement. So it's right at the upfront when you're drafting your agreement, you're incorporating the situations and contemplating the situations in your agreement. Now, that time you would ideally know the nature of your agreement, the nature of the disputes that can arise. You would want to consider whether you want a sole arbitrator there or you want a 3-member tribunal. Complex cross-border disputes, technical disputes, I would suggest better to have a 3-member tribunal in that sense, because at least there is enough people on the tribunal who will be able to handle it, complex disputes. But if it's a smaller dispute, comparatively easier run-of-the-mill disputes, you may consider a sole arbitrator. So depending upon the nature of your contract, you could probably decide on that. It's very important to know your disputes, the nature of your contract when you are actually appointing an arbitrator. I think that's very, very key.
Right.
And also, sorry, one more thing, if you don't mind. The cost is always going to be an issue. And with a sole arbitrator, you're going to face much lesser cost as compared to 3-member tribunal. And that's what Mr. Hemant Kumar also mentioned, that cost is always an issue. And you will find the same issue in domestic arbitrations or in international arbitration. at least with virtual hearings now, the cost for traveling of these arbitrators have come down. So that's to that extent, I would say the cost is going to come down a bit.
Right. So John, let me ask
can
you
I
this.
add?
Yes, Mr. Kumar, please go ahead. Yeah, Hemant, sorry, go ahead.
Yeah, and one live case I'm just sharing with you about contract provides for 3 members consisting of 3 members tribunal. See what happens. The first there some party, a very big public sector, invoke arbitration against us. In India, when a single judge of Supreme Court pronounced order, we accept it. When division bench pronounced, we accept it. Why do we insist for 3 members at all? That is my big question. So I accepted the big public sector appointed ex-retired judge of the Supreme Court of India. I accepted it. And finally, the award has come. So that mindset of the client, our general counsel has to be also in such a way that he is not he's a lawyer or he's an advocate or his law firm. He is a neutral arbitrator. So notwithstanding, there is a provision for 3 members. If you find that tribunal suggested sole arbitrator suggested nominee by the other side, and if you accept it, there is nothing wrong. Do you think that if 3-member tribunal is there, you will always get the favorable award in your favor? Answer is no. And why should we think like this? We are LNT, we have taken a lot of cases where 3 members were there. We have accepted 1 only. So this is one part. Second part, reduce. How to reduce? We have explored our own way. If you are a claimant, you are aware of your SOC statement of claim. Why don't you before invoking even keep your SOC ready, keep your expert duly certified your statement of claim and amount ready, and minimize to have only 1 or 2 witness. You see how many days, how many months you can reduce. You can easily get in 12 months under the Indian arbitration.
Yes, and Hemant, I think I was thinking you're a mind reader because you almost took the words out of my mouth. This was going to be my question to John actually. That John, we talk about these these costs, and of course enforcement and neutrality is the is what you get in return. But what's the guarantee of neutrality? How can we be secure that the tribunal will really be independent and impartial?
Well, I think the first point is that the international standard undoubtedly has now become a requirement of impartiality and independence. And it's not that long ago, when I was on the board of the American Arbitration Association, that there was a tremendous fight between the domestic US arbitrators and the so-called internationalists. Because the American tradition had always been that a party appointed an arbitrator which would be its spokesman, or who would be its spokesman on the tribunal. And getting the switch in the United States to the general acceptance of the international standard of impartiality and independence is quite a task. But if you look now, it's certainly the case that the places where one is almost having to expect to deal with a partisan arbitrator are becoming fewer. They're not gone, but they're fewer than they were before. What will happen at the start of certainly every institutional arbitration and any arbitration held ad hoc under the answer trial rules is that a would-be arbitrator is required to fill in a declaration, a statement of independence. And with that comes a duty of disclosure. And as David will know, and those of you who practice in India internationally will know, the stakes of disclosure have become ever greater. We haven't yet got to the list, thank goodness, that prevails in California, where you're hit with a list of something like 27 pages in length, which requires you to go down to whether you've ever shared a barber's shop with another member of the tribunal, or you've ever had lunch with someone. It's absolutely crazy. But we are pretty far down the line. And things that 10 years ago, certainly many civilian arbitrators would never have dreamed of thinking necessary to disclose are now regarded as pretty well necessary and important. And I think it's fair to say that most of us who have the privilege of practicing on a pretty regular basis will take a view that if in doubt, disclose and err on the side of caution. It's sometimes you think, well, why am I doing this? But at least then there can never be any argument that something has come up that the parties weren't aware of, and it can then be blown up into something which is quite ridiculous. So there is that, if you like, guarantee of a basic starting point of independence and impartiality and a duty to disclose. The parties do, of course, have the ability to challenge. But it often doesn't come to that, because even within a tribunal, there's a power of self-regulation. It becomes pretty obvious pretty quickly if somebody is inclining to one side and the side that appointed him or her, their interests above all other. Sometimes it's possible to talk things around, sometimes it's not. But again, this is where the role of the tribunal chairman becomes quite important, because you can end up in the most extraordinarily difficult position, and it really becomes a balancing act. And if you want to see where things can go wrong, look at the Lauder case, the Czech Lauder cases, where there was a real suggestion that an arbitrator had been frozen out of deliberations. And there are other cases where eminent arbitrators have been hauled in front of the Svea courts in Stockholm to explain what they did in deliberations. So these matters really have to be considered very carefully. But one can challenge. But it's also true, I think, we have to keep this in perspective. The number of cases where a challenge goes to court and is upheld is actually pretty small. And the reality is this: if there is egregious behavior on the part of an arbitrator, it is very unlikely that the arbitrator will ever be appointed again. And that's a pretty powerful sanction. And if it is egregious, it becomes very widely known very quickly. And a classic example is the Slovenia-Croatia border dispute some years back, where calls were taped between one of the party's arbitrators and an senior official of the government concerned. And that resulted not only in the departure of that arbitrator, but indeed the other party-appointed arbitrator, because it then turned out that something similar had been going on the other side, leaving the poor chairman entirely alone until the thing was reconstituted, finally with a tribunal of 5 arbitrators to sort it out. So it can go horribly wrong and become horribly expensive. But the reality is that a lot of these challenges are actually pretty frivolous and can be explained away. The all-time classic, I think, was probably an eminent Australian arbitrator who failed to realize when he pressed send that he'd replied to all instead of just replying to his colleagues, and issued a pretty blistering comment upon the conduct of one of the counsel then in front of him. This went to the LCAA, which took a rather strange view about it, and quite rightly dismissed the challenge, but it went on to the court. Again, it was dismissed. But the best line of all came from the arbitrator concerned, who, when he was pressed on the point, said, well, I didn't say anything in the email I wouldn't have said to his face. So that goes down towards the more frivolous end of it. But the reality of all of this is that what one's dealing with here is not so much independence and impartiality. The big issues really are conflicts, getting people appointed in the first place, particularly arbitrators who serve in large law firms, or indeed these days in barristers' chambers, because although the bar understands how the bar works, internationally it's still regarded as a rather strange proposition. And therefore one has to be very careful about how one deals with it. So conflicts are a big issue. And the other one, and I'm sure David would agree with this, is availability. That's the real key, because people tend to want to go to people whom they know can be relied upon to do something sensible, and they tend to be busy. And then quite recently, of course, the thing has turned around, because there's been a number of occasions where I've been able to say as a tribunal member, looking hard at counsel, well, we can do a certain date, how about you? And then, of course, it comes out that they've done the usual thing. They've gone on their beauty parades and they've taken all this work on. And of course, there's a crash of dates because hearings come together and it's very difficult to accommodate. So it cuts both ways. But I would keep this concept of whether or not you've got an impartial and independent tribunal in context. Sometimes there's a problem, sometimes there's not. And I'll finish with this. Not many years ago, representing a very large European conglomerate for high stakes, in front of an eminent tribunal chaired by another European who was a professor who had certain views about factual evidence of fact. He regarded this as a bit of a waste of his time. He was only interested in the expert evidence. And we ended up producing the managing director of this European conglomerate to give evidence. And when he appeared, the chairman of the tribunal looked at him and said, "I know you're the managing director of a certain European international company, but nonetheless, I do expect you to tell me the truth." There was no challenge.
Fantastic. I think your explanation of the traditions that underpin arbitration has been really excellent and riveting for me. So thank you for that. Dras, if I might turn to you in terms of looking at it, if there is an international arbitration taking place, in what circumstances might an Indian court really intervene to help a party in an international arbitration?
Thanks, Bharat. I'll be quick because I can see the clock. I think what's happened in India is that there's been a sea change in positivity about arbitration in general. And I think Hemant made that point when he referred to the 2015 amendments. It didn't come only with that. There was a change in the view of courts as well, but about between 2011 and thereafter, and of course the 2015 amendments gave it a huge fillip. So I just focus on three areas, but I think now our courts have become proactive in assisting the arbitral process and in assisting arbitration as a whole. The first, of course, is the interim order. I think increasingly, even in arbitrations seated in India, and I would count those as international arbitrations as well if they have a foreign party, courts are inclined to make strong interim orders, including of deposit or security for the ultimate award or claim. And I think that's a step forward because it really puts a premium on meritorious claims and it penalizes recalcitrance on the part of the defendant. In the same vein, they've also recognized emergency arbitrator awards made internationally. They've recognized interim awards made internationally, though these don't have direct enforceability, as they don't under the New York Convention. Indian courts increasingly have been looking at them very favorably and taking them into account while passing their own interim order under Section 9. And of course, with the 2015 amendments, Section 9, which permits a party to apply for interlocutory reliefs, became available even in respect of foreign seated arbitrations. So you've got the first part of court facilitation is an interlocutory relief. The second area is, of course, the challenge or the enforcement, depending on whether it's India seated or not. The 2015 amendments made a huge change in terms of the scope of challenge to awards in arbitrations, albeit seated in India, but international commercial arbitrations. The 15 amendments eliminated the ground of challenge of patent illegality. And with that went away a huge number of challenges which were sought to be squeezed in by parties. And the amendments also made very clear that the challenge on public policy grounds were extremely narrow and restricted to just 3. So I think that helped. Effectively, the domestic ground for challenge even on public policy has been equated to the New York Convention enforceability ground. And the Supreme Court has said so in judgments thereafter. So you have an extremely narrow challenge, even in India-seated international arbitrations, based on a very narrow view of public policy. So that's the second move forward. And of course, that same approach is carried forward when it comes to enforcing foreign awards. And one of the recent decisions, of course, concerns David, one of his awards, which I think he was the sole arbitrator. And the Supreme Court has had much to say about what fundamental policy of law means. It rejected the objections to enforcement and said, you have to restrict fundamental policy of Indian law only to time-honored, haloed principles and nothing more than that. And it, of course, rejected the challenge to enforcement of David's award. That's pretty much been the trend of the Supreme Court and of the Bombay, Delhi and other high courts for the last few years. So very pro-enforcement. So that's the second area. The third, and this is where Hemant did make a very good point on costs, because we do tend to forget that the real stakeholder in all of arbitration is the litigant. It's the ultimate party autonomy, and it is a question of that really concerns the litigant much more than it concerns us lawyers as to how cost-effective a forum or an arbitral tribunal is going to be. There's been a little progress there. You're seeing bigger awards of costs. The 2015 amendments brought in Section 31A, which now give a very detailed matrix on how a tribunal is expected to approach and impose costs. They import a large section of the English provision, and it's a very detailed sort of roadmap for how to award costs and how to encourage awarding of costs. And I think I can see that happening increasingly, certainly from arbitral tribunals. And that itself, I think, will speed up the process, will eliminate frivolous applications, and will be all to the good ultimately. So I think these are three areas where courts have intervened, and it's been positive.
Thank you, Dries. So, just keeping an eye on the clock, I think let's turn to some of the audience questions. I think, Kinshuk, if you don't mind, I'm going to put the first one to you in terms of some of the tools available to save time and cost in an international arbitration. We've heard a few recommendations already, but quickly give us your views.
Yes, I think the general consensus amongst arbitration users is that, look, arbitration is definitely a faster process as compared to litigation in court. But I don't think everybody is so sure about costs. I think there is still a concern around how much an arbitration can cost. And really, to address to address this particular concern, institutions have come up with very innovative tools. And I will very briefly talk about, I think, two of them, because there are several, but I understand we don't have time to go through the entire list. The first one, Raj very briefly alluded to, is the procedure for expedited arbitration. I don't know if Raj mentioned it, but expedited arbitration procedure is one of the very commonly used tool in international arbitration. You will find this in the SIAC rules. You will find it in the MCIA rules. You will find it in the ICC rules, and you can avail this when your amount in dispute is under a specified threshold. So if your stakes are not very high, the amount in dispute is very low, this is a tool that comes in very handy. And just to give you an example, under SIAC rules, if the amount in dispute is lower than 6 million Singapore dollars, which works out to about 32 crores in Indian rupees, you can avail of the expedited procedure. ICC, that threshold is $3 million US now for all arbitration agreements entered into after 1st January 2021. MCIA 2, I believe, has a threshold of about 10 crores. Now, what is this expedited procedure and how does it work? So if you pick this procedure because of your stakes, 3 or 4 things happen. And the first one is very interesting, because you did mention and you asked that, the question was put to Raj, is there any way you can pick a sole arbitrator, even where parties have picked or chosen a 3-member tribunal? Now, what this expedited procedure does is there is an automatic appointment of a sole arbitrator. So your case will be referred to a sole arbitrator irrespective of the number of arbitrators that you've picked or chosen. So I think that's a very important point. Otherwise, the time period, all time periods get abbreviated to some extent. So your case management conference will have to happen soon after the constitution of the tribunal. The tribunal will encourage you to pick a documents-only arbitration as opposed to holding physical hearings. Again, something that can expedite the proceedings. And finally, in most of these rules, the tribunal is expected to pass its final award within 6 months odd from its constitution or from the first case management conference, depending on which rules apply in the arbitration. So that's, I think, a very helpful tool. The second one, very quickly, that I think is helpful is the early determination or summary dismissal rule. This is again unique to most institutional rules, like SIAC has it, LCIA has it, which basically allows both the claimant and the respondent to apply to the tribunal for an early dismissal of the claim or the defense, if either the claims or defenses are found to be manifestly without merit, or they are outside the jurisdiction of the tribunal. Now, often enough we have clients in court litigations asking us, look, how do we put an end to this litigation? And we find ourselves tearing our head because there is no easy way to put an end to a litigation in court. It's a long drawn affair, but institutional arbitrations give you that opportunity to file a claim, to file an application to get the proceedings dismissed quickly. So those are two tools, Bharat, which I think are very helpful and often used.
Yes, of course. And, Deepak gave us the very practical point of picking the right team and leveraging off the network that you already have if you're, sitting here in India. And I really like the point about, boutique firm, an Indian firm, even if it's a low value arbitration, but you could still avail of the benefits and the conventions of international arbitration in that context as well. So maybe, one more audience question, Drais, if I could, ask you, and, this is again something to help the general counsels in the audience in terms of the differentiation between the rules and the presentation of evidence when it comes to international arbitration, and how is it different in the Indian context, and what does this mean for Indian companies looking at international arbitration?
So it boils down to who's conducting your matter for you and your legal team. Increasingly, even in India-seated arbitrations, the style and manner of presentation is moving towards the international style. And by that I mean it is more dependent upon the written word than it is upon the oral word. We have a tradition in our courts of the oral tradition. Basically, no one ever stops a lawyer from arguing, and lawyers can argue indefinitely, as we know. All that adds up to huge amounts of costs for the client, and therefore, particularly in arbitrations, that's really a wastage which we can no longer afford. So increasingly, even in domestic seated arbitrations, you're having time limits for arguments. Internationally, you have, of course, the chess clock system where you just divide up the time, whether it is for cross-examination or for arguments. Internationally, you always file detailed written submissions before the evidence even starts. Something which would be anathema to an Indian lawyer in a domestic arbitration. But increasingly, again, in India-seated arbitrations, that's happening. You are required now to, as it were, disclose your hand well in advance. So your opponent is not ambushed. Everyone knows what judgments are going to be cited. Everyone can focus on the real issues and controversies that have arisen. And that makes for a speedier and I think a fairer arbitration. So you've got to be ready when you're doing an international commercial arbitration, particularly with arbitrators who have international experience, to be able to cut short your arguments, to be able to focus them, to be able to put them in writing, and to cut short your cross-examination. You don't have to go on and on and on. But as I've always said, Indian lawyers are really very talented. We have the ability of being schizophrenic in our approach. So the same lawyer who could take days of argument in an India-seated arbitration will be able to quite competently finish his argument in 3 hours before an international tribunal. So I think that's the way things are going now.
Right. No, thank you so much, Drais. And with that, I think that's all we have time for, both in terms of the panel and in terms of the audience questions. So covered a lot of ground. Kinshuk, could I maybe trouble you to summarize maybe 3 takeaways from today's webinar that people can reflect upon later?
Wow, it's difficult to pick 3, Bharat, because I think it was a very, very insightful discussion. But I think for me, the consensus seems to be that international arbitration, or arbitration for that matter, should definitely be the considered the preferred choice of dispute resolution, especially when it comes to commercial disputes. I think that seems to be a universal sort of consensus. We understand that arbitration is a feature of contract. David mentioned about making sensible choices. I think that's very, very important when it comes to arbitration, because all too often we find ourselves dealing with an arbitration clause, which is, to politely put it, is completely unworkable. And really, that's where I think a lot of attention needs to be put in. pick your seat very carefully, pick your arbitration, the law governing the contract, the law governing the arbitration agreement very carefully, the strength of your tribunal, the institution that you pick. The point is, spend some time looking at that arbitration clause. I think that's something that we all need to do more carefully. And lastly, on a positive note, I think we heard some of the speakers mention that more and more we are finding India as a preferred seat, especially for Indian clients, and there are good reasons for that. I won't repeat those, but I think Hemant kindly explained many of them, and so did Rais. So those are really my key takeaways, Bharat, very briefly.
Thank you, Kinshuk, for your insights. And can I request the audience now to help us in terms of our continuous improvement endeavors and just respond to a poll. I'll request the poll to be put up. It will just take you a few seconds to perhaps respond to this. We'll keep the poll alive for about 30 to 45 seconds. So finally, I would just like to thank each of our guests for making this session possible and for sharing their experience and expertise with us today. John, David, Rais, thank you so much for sharing all your inputs. You did an outstanding job, and really, we are very, very much indebted to you for all your knowledge and expertise. And making this an invaluable session for the entire audience, and including especially me. Really learned a lot through this interaction. Hemant and Deepak, thank you for sharing your first-hand experiences. You are, lead the battle in some ways, for clients, and for bringing, that perspective in. Give us a lot of food for thought to think about in terms of how we approach these situations and these challenges. Sincere thanks to each of the members of the panel for having devoted their time and effort in making this event possible. To the audience, I hope you found this webinar interesting and a useful investment of your time. We certainly enjoyed bringing it to you. After the webinar, all the attendees, the webinar attendees, that is the audience, will receive a copy of today's presentation materials and a link to the webinar recording. You will also receive separately a request for feedback on the webinar. Please take a moment to give us your invaluable feedback. It's a part of our continuous improvement exercise, and any comments, criticism, even compliments will be helpful. It'll take you less than a minute to complete this form. Please do not hesitate to contact any one of us for any questions arising from the webinar or any clarifications that you require. Our contact information is on the slide before you. Thank you for your attendance today, and we look forward to being of service. Thank you.
Thank you all.
Thank you.
Thank you. Bye.
Thank you.